Question is this bill be read a second time. I call a member for Heffron.
Mr Acting Speaker, I make a contribution to the Fair Trading Legislation Amendment Consumer Guarantee Directions Bill of 2018. The member for Swansea has committed the bill to the House, and I take no issue with that. In fact, as I have observed to various amendments relating to consumer protection in this House for a number of years, the Office of Fair Trading or Fair Trading Department has made a number of considerable and valuable suggestions to this House to effect changes in legislation. I think I observed with the Minister's predecessor that I thought that he was implementing changes to legislation in the best traditions of that great Labor Consumer Affairs Minister, Sid Einfeld, and I must say that the current Minister seems to be continuing on that path. This is a fine piece of legislation. The history of sale of goods and consumer protection has been grappled with in this House since the 19th century, or in 1896, I think, is the first time this Parliament has sought to implement sale of goods legislation in an effort to protect consumers. Again, I think in about 1924 to 1926, and again in 1969 in its Sale of Goods Act. In 1969, the Parliament sought to imply conditions and warranties for the protection of consumers. However, the Parliament's legislative remit only extended, of course, to private individuals or businesses that weren't corporations. And they highlighted another problem, and that was the ability of consumers to be able to enforce those implied conditions and warranties. Now, those implied conditions or warranties were that the goods had to be of merchantable quality and that they also had to be, in effect, fit for purpose. However, in 1975, the Commonwealth Parliament enacted the Trade Practices Act, which in effect mirrored much of the provisions of the Sale of Goods Act and gave federal power binding corporations to a variety of implied conditions and warranties in respect to the sale of goods, and also for the first time applied services to not just sale, there being implied conditions and warranties in respect of the provision of services. However, the problems continued related to questions of enforcement, and that is, how is a consumer who maintains that the goods he purchased weren't of merchantable quality or fit for purpose? In other words, if a consumer relies upon the advice of the seller and the product does not meet the representation made by the seller, then there is an implied breach in the condition of that contract of sale. So where does a consumer able to obtain remedy? The remedies were, of course, expensive because there had to be access to courts to enforce that remedy. Secondly, the then Department of Consumer Affairs tried to remedy that situation through the then Public Solicitor's Office providing, under the Consumer Protection Act, legal aid. The matter then morphed to provisions relating to the establishment of a tribunal, which is now in various forms, which is now NCAT, designed to give a relatively quick or cheap way of being able to resolve these sorts of disputes. But even those have become expensive and time-consuming and of no benefit to the small consumer. That's why this bill that has been proposed by the Minister is so significant, because it means that any consumer of a product, its purchase price is between $25 and $3,000, has access to the Office of Fair Trading where there has been a specific breach of a contract for sale of goods. When I say contract for sale of goods, if I buy something from you and you provide me with the goods and I pay you, that is a contract for sale. No different to any particular purchase. It is a contract and a binding contract. Now, in those contracts are applied by law conditions or warranties of that contract. As I referred to earlier, of merchantable quality or fit for purpose, or for example, relying on the representation of the seller. Now, what is proposed in this bill, which is particularly clever, is that it has adopted something that I remember arguing about 20 and 25 years ago, and that is that it is adopted the wording of the conditions and warranties that exist in what was a Trade Practices Act, and now I think they call it the Consumer and something else Act, or they call it Australian Consumer Legislation. So you will notice in the bill that it adopts sections 54 through to section 57 of the consumer protection legislation, which standardises in respect of those purchases between $25 and $3,000 the applied warranties that are contained in federal law. So, for example, in section 54 of that Commonwealth Act, where it says, where it requires a guarantee to acceptable quality, subsection 1, a person who supplies in trade or commerce goods to a consumer and the supply does not occur by way of sale or auction, there is a guarantee that the goods are of acceptable quality. And they are of acceptable quality in subsection 2 if it is fit for all the purposes of which the goods of that kind are commonly supplied, B, acceptable in appearance and finish, C, free from defects, and D, safe, and E, durable. So it matters not it matters not what anybody might say, or whether somebody says it or doesn't say it when a consumer goes and purchases a goods. By virtue of the adoption of, say, section 54 of the Australian Consumer Law, every purchase by a consumer has those provisions as a part of that purchase. And so a consumer reaches a level of protection now in this state, if this Parliament enacts this bill, that a consumer has never had before. But where this bill is successful, and this is where, and it's some reluctance that I have to commend this left-wing Liberal minister, but where this bill is particularly successful is that he has just not proposing the enactment of a law that protects the consumer and beats his chest and says, well, see, look what I'm doing. He's actually setting up a framework that enables the consumer to go to fair trading in order to have them resolve and make orders in respect of that product. Now that means, now that's a terrific thing, because all of us have dealt with people that are not affluent, and in fact most people haven't got the ability to access legal advice over relatively small particular purchases, nor do they have the resources to go to the tribunal. It means that anybody who gets dudded, even if it be a pensioner in social housing, gets dudded by a door-to-door salesman for something that's not fit for purpose, in breaches of section 54 to 57 of the Australian consumer laws, they may make an application directly to the department to have those issues resolved. And that is a huge step for this state to take to protect consumers. I think that the Office of Fair Trading is probably going to be inundated, and as the member for Swansea made some reference to the need in the future for the organisation to make sure they're resourced so that they can deal with these particular issues, because I think they're going to be inundated. In the future, though, that will probably drop off as sellers realise that if they are going to dud consumers, there is a government organisation that will hold them to account. Mr Acting Speaker, might I have an extension of time?
Oh, no, don't. Rob.
Absolutely.
Don't.
Against my better
Keep going, Ronnie.
against my better judgment, the member for Heffron. Order. The member for Heffron requests extension of time. Is there an extension of time allowed? All those in favour say aye. Against say no. I think the extension has been.
Now I'd hazard to guess, as much as I personally like the Minister for Better Regulation, I'm sure he has no idea what I'm talking about. The other issue I want to observe too, which is a rather novel situation, is the legislative intervention to control the function of plumbers. I imagine, and by that I don't mean the Watergate plumbers, but by that I mean that obviously the Office of Fair Trading has been dealing with an excessive range of disputes relating to the quality of work of that particular industry. The reason I draw that inference is because it's apparent that industry has been singled out in this legislation and not perhaps others. So I would imagine a lot has been occurring in the sewers around Sydney that need some sort of legislative intervention. We all get stories about the activities, but I accept if the Department of Fair Trading say that this is an industry that requires special legislative control, that there would be a need for it. They have had a very good track record over a number of years representing consumers. On the whole, this is groundbreaking. This is a groundbreaking bill that really does benefit consumers. It is extraordinary coming from a party that generally would protect businesses and sellers to provide consumers with protection, and that is, if you look at the history of this sort of legislation in New South Wales, or if you look at the history in the Commonwealth in relation to the Trade Practices Act, these sort of provisions are usually enacted by Labor governments, not by Tories. So obviously this left-wing minister is in a position to be able to persuade his colleagues about the importance of consumer protection. The bill is a good one. It will need constant review to make sure it's successful, and as a member for Swansea said, it will need resources, but really it is probably one of the best consumer protection provisions to provide accessibility to the sort of people that my party usually represents, and I commend the bill to the House as well.